Hello and welcome to Regional Counsel, presented to you by the Singapore Academy of Law. My name is Nicole and I am your host for today. Regional Counsel is a series of short video podcasts on legal content catered to in-house counsel who are new to ASEAN regional work. This series is not meant to be a deep dive, but to equip in-house counsel with tips and tricks from experts of Indonesian law themselves to navigate the challenges faced when dealing with jurisdictional specific quirks. In today's episode, we'll be delving into litigation with Dr. Santy Kouwagam, researcher and postdoctoral fellow at the Leiden University. Yeah, is there anything I've missed out that you would like to share? Tips and tricks that in-house counsel would find useful to know, or things that your older self would tell your younger self. These are the things that are actually the points that have actually helped you in your practice. That could value add to someone's understanding of Indonesian law and also dealing with Indonesians.
I think learning from, like, looking back now from all the people that I work with or post with, it's always helpful to be flexible if you are dealing with Indonesian law or even an Indonesian. Um, I tend to find lawyers from other jurisdiction, either from the US or Singapore. They want to translate everything into clear, something formal. They want to look at it in black and white, find it written, but a lot in Indonesia, you cannot understand if you have that kind of requirement in your mind. A lot of things are unspoken, a lot of subtlety that even today I keep learning what people are trying to communicate by not saying it. So it's it's something.
That's so tricky.
Yeah, I think you just need to be sort of flexible, be creative, and I think also just don't be afraid to ask someone to clarify,
Okay. Yeah, that's very useful to know.
or not clarifying by asking like, oh, what number is the law, but clarify like, oh, what do you mean, what is good for you, or something like that, because often a lot of things are unsaid,
I see.
unspoken.
Okay. Yeah, that's quite tricky.
Yeah. So this communication is something you also need to keep in the back of your mind, also when litigating, right? Because when to get the information is one of the most important aspect of the litigation, is the timing of it. So the yeah getting information is something very important uh, to know how to do. Also in my book, I wrote about the chain of
Okay.
command, and I think you also mentioned it a little bit. Um, so there, it's helpful to know, to make it clear when you are litigating, to know who is the executive of the case, who can decide strategy, and who are responsible to carrying it out. Now, as an in-house counsel, of course, the first instinct is to have the in-house counsel be the driver, the controller of a case. But usually, when you're engaging a litigator, they often don't like this. So this is a source of friction. So yeah, because the litigators or the fixers, they often say, I want to deal with the patron, the owner of the business directly. So that's what is sometimes required. So in-house counsel sometimes need to step back from a litigation, but that's also a practice that I wrote in my book, that is not that also indicates an unclean practice, because yeah, but that's something you need to be prepared for. I hope less and less, but it's still there.
Yeah. Thanks very much for sharing that. Because it just sounds rather counterintuitive because most times corporations have in-house counsel to manage the litigators. But as you mentioned, sometimes the litigators want to interact with the decision makers themselves, so that they get clear instructions and they can influence the decision. And of course, there are costs associated with hiring external lawyers, right, litigators to the case. And sometimes it's not in in-house counsel's interest to engage them early as well because they're trying to manage the situation internally first before they go external. So I see the tensions there. And like you said, there are bearings on the outcome, depending on, who drives the case and, who's willing to take the responsibility for it. So that's something food for thought, especially for those of us who are in in-house roles. I thought that was just good, something good for consideration, knowing that there are situations like that could play out, and the difficulties for in-house counsel.
Yeah, and I think if once you get a litigator or an Indonesian lawyer that you can trust, I think that would make everything easier. That you Yeah, that's what I always say. Like the step to enter Indonesia is very big. It takes, but once you're in it, it's very easy to navigate.
I see. Okay, so you just need that crucial contact point in Indonesia. And on that note, are you still taking cases yourself? Do you still take cases and practice law in Indonesia?
No, I usually advise businesses on. I actually monitor the lawyers in the background, so I make sure the lawyers are reputable, playing nicely, and then I would keep an eye on the lawyer. But I usually I'm engaged for that. I think about the strategy. I reassess whether that this is a good step, and then I advise the client directly, but they have an Indonesian lawyer. I also recommend, sometimes I look for a match for an Indonesian lawyer for them. So I could that's also something that I could do.
Ah, okay. So these are more like consultative
Yeah,
consultative services on your
yeah,
part? Ah, okay.
yeah. And I like it because it's also, I can, like I can say, oh, yeah, I don't know whether this lawyer is, you need to reconsider something, because in a way that I'm also participating in making the practice better. But
Mm.
yeah, so
Yeah, and you're smoothing and having less friction for the chain of command by helping to
yeah,
match the
because
lawyers.
sometimes also the lawyers, even though they are good and they are really, sometimes they would drag things, and then I would s- I would, I sometimes say, oh, to the client, I think you can make this more efficient, something like that. And so I give them tips on the background. Sometimes they also ask me
Mm.
who's the good lawyer to handle this case, and then I can also provide it for them. And yeah, because
Yeah.
also keep in mind, a lot of
Mm.
litigators
Okay.
still, they, especially the ones who always win, or claiming that they always win, they don't they select cases. So if a
Mm-hmm.
client really needs someone, you know a particular lawyer, it's not often that they would accept it. And then they would think about, because lawyering is also a
Mm.
business, right? Like whether they will have enough um,
Mm.
fee. They could actually charge their fee. Or also a really important aspect is that usually they would think, oh, this party is who I am going to oppose at. But they would think of a network, like, oh, if I act against this group, it's not good for my network. And this is not only network in business people, but also a network in law, like the prosecutor, the police, the judges, like. So these lawyers, they can refuse cases on the basis of that, and they are still allowed because in our uh, law for lawyers, lawyers are required to only accept cases that they agree in their, we call it hati nurani, which means like your inner conscience, like in the law for lawyers. So they can refuse cases based on that, but usually it's because they don't want to go against their network. So also be prepared that some cases, especially if you're a foreign party, um, it's also very hard to find a lawyer who will act, or a litigator, not a lawyer. Yeah.
That's very useful to know. There's so many difficulties and challenges, but at least you've put it into words in a book and you've explained it here to us, and that actually shed some light on the complexities of the landscape of litigating in Indonesia, given the informalities of the system, certain principles, certain networks of people, and the different types of courts, and even the numerous levels of appeal that one could take, in the courts, as you shared
Yeah.
earlier. Yeah, so all these things are pretty much unknown to me because I've never practiced Indonesian law. I've not dealt with Indonesian counterparties before. So that has been very enlightening. Are there any other thoughts that you wish to share in this podcast? I know I've helped you for quite some time, but are there any other tips that you would like to share on this podcast before we wrap up?
Oh yeah, that's also one important tip, because it's really criminal law is something that you cannot avoid in disputing in Indonesian law. So that the in my email I mentioned about protecting um, the client if something happened. I mentioned that they shouldn't, if there is a new business, that's also an important aspect to watch out. So if the counterparty is someone that you don't know quite well yet, is the first time doing business, and you're not sure about the terms of the contract, I advise that the signatory is not someone who plan to go to Indonesia. It sounds really it doesn't sound good, but that's a that's an important, yeah, it's an important advice, because I've seen so many foreign clients that they either get a red notice, or they get a criminal decision, criminal court decision against them. So it's better that if there is this business that you don't trust yet, make sure that the signatory is not someone who wants to go to Indonesia or is living in Indonesia even.
Okay. When you mentioned red notice, could you just explain a little bit about what red notice is?
Oh, red notice is when it's a criminal notice that the Indonesian police or any country's police can put a red notice to the Interpol that you're basically a wanted person to be tried in Indonesia or in the country. Yeah.
I see. Okay. Is this what could potentially happen if business dealings, fall out, even if there's no criminal conduct? There could be allegations made against the foreign party.
Yes. Yes, and we are seeing it now. We saw it in 2000, was it 2009, with the Century bailout case. So we keep seeing it, especially in a big amount of dispute. Also, if it involves yeah, banks, usually it's something dispute with banks is yeah, this could happen, or there is a transaction with the Indonesian government
I
to
see.
with procurement, for instance. This is something that is very
Mm-hmm.
yeah, this very important to
Mm,
watch out for.
okay. I suppose in-house counsel should inform whoever is going to sign this to just be aware of certain potential threats or things to be
Yes,
aware of
exactly.
if that come with signing. It's not just whether they are authorized
Yeah.
director, for example, to execute. Perhaps they
Yeah.
can't go to Bali for vacation in the event things go south. Yeah, I think that will be the implication, the more immediate implication.
Yeah,
I mean, if they are
exactly.
not routine
Yeah.
business travelers to Jakarta, for example, or to the new capital. Okay. Thanks so much for sharing all of that. I mean, it did sound a bit foreboding, but I really enjoyed having you on the podcast. It's been really, really helpful. I think in-house counsel would, have a lot of things to think about, and also tips and tricks that you've shared, especially when it comes to appointing, local counsel, local lawyer in Indonesia, and also some of the things to observe doing business in Indonesia, like the concept of zhengli. I'm very glad that you spelled out. So for listeners here who are listening on this podcast, Santy has written a book. So thank you so much,
Yeah.
Santy.
The book is actually in
Oh, the
Indonesian.
book is in English.
I have an Indonesian book.
Oh, wow. You have it here. It looks great.
So it's an Indonesian translation of my thesis, which is online that you can that is open access because it's a scientific production. That so the English version is free and online. This one, but the book is in Indonesian because that's my main goal of being a researcher. So I can tell Indonesians this is how your law works.
Yeah, sometimes it's not apparent to people who don't practice, right? And who don't see it in action. Yeah. And hopefully some
Yeah.
developments can be made to make it more accessible to people who don't usually engage the law. And yeah, at least for us here, for myself, just speaking with you, and I'm sure for the in-house counsel who are tuning into this podcast, it's very helpful because you put into words, some things that are sort of unspoken, or it's difficult to put things into, just English, right? And in a language that can be understood. So yeah, thank you so much, Santi. It was great having you on the podcast.
You're welcome. Thank you.
Thank you so much, Dr. Santi, for joining us on Regional Counsel. If you have found this episode helpful, please stick around to learn more with us. This has been Regional Counsel, a production by the Singapore Academy of Law. Thank you.